I had to prepare a couple of slides, but then they don't, I'm going to skip it. I'm going to just go speak a little bit off the cuff. Also, because today has been a very interesting debate in all panel, in all discussion. Many of the points have been raised. Many of the issues have been already acknowledged. So I don't think actually there is much need for me to go through all of this. But I'd like to point out a couple of the items that have been actually pointed, discussed today. And as we seen, it came out pretty evident, from the discussion today, that when we're talking about the platform economy, we're talking about something that is very, very broad and something that encompasses a very different way of organizing work or providing services, or even just different type of services that you can provide, which comes with a lot of challenges, because it basically means that it's going to be very difficult to find a sort of one-size-fits-all measure that would be good enough to encompass all the peculiarity that might arise. However, there are some regularities that you can actually, track down on the way platforms and on the way particularly platform work is actually expanding and developing in different parts of the world. And what we see is that there are 3 or 4 features that are always basically present. And the first one is that the first is clearly the increased availability of data and data storage. Platform would not exist if it didn't exist access to data, and if it didn't exist the possibility of actually crunching this data in order to get important information used for the organization of the business, the organization of the workers, and also, connecting people who are in very different parts of the world. So this is one of the elements. The second element is the use of algorithm and data analytics in order now to make this data actually making sense somehow and be actually useful and effective and productive for whatever scope it is that they are used for. The third one is digital labor platforms. Now, this morning in the discussion, what we heard, for example, is that many times, when we were referring, people were saying digital platform, digital labor platform. This is one of the first initial important points. What it is that we're talking about when we're talking about platform work, and what it is that we are trying to define when we are trying actually to narrow a little bit the scope of the intervention over a potential regulation that we want to look at. So this is not a very easy question to answer, because the blurred line that you might have, between different type of organization and different use of digital tools, it might actually leave some area which are a little bit gray, which are not very well defined. So this is one of the main challenges, because I don't really think that we do need to reinvent the wheel for things which are kind of obvious, where actually what you change is just the way in which you are providing the services, but actually you're not changing the core organization of work. You're not changing the core dynamics. Those are the easy cases. The cases which are a little bit more tricky are the one where actually you have difficulties in understanding if this organization are actually behaving or not as employers, or they are behaving as intermediaries, if actually workers are actually workers in the sense of employees, or are actually self-employed or business users. So those are the tricky part, and this is the real challenge. Starting to understand how do we want to frame this. Now, I'm not gonna coming up with answer. So if you're expecting an answer to this one, there's no answer to that one. I'm not providing an answer to this one. But what I'm trying to say is that when we try to approach this issue, we have to try to look at which are the fundamental questions and which are the fundamental characteristics of platforms. One of the things that is clearly associated with the adoption of algorithmic technology and the use of digital labor platform is the fact that what were once considered traditional jobs have been somehow fragmented in small tasks. And this task could be somehow outsourced in a very, very long global value chain. And I say global because what happened now, it was very difficult. Imagine if you would hire someone to make a translation, of a very short pieces on the other side of the world. It would have been absolutely cost inefficient. It would have been almost impossible. Today, it's very easy. You just go on a platform and you just ask for this piece of translation. And so what you have is that someone else in the other part of the world might pick up the job and might decide to translate it. So this is just a very, very, trivial example of what it means, like this abandonment of task, and how this is changing the value chain. Now, What is our role there? It is try to understand how this could become an opportunity and how this could become a challenge. So it is true, as been pointed out today, that platform might open up to new market. The platform might actually reach, we heard this from the World Bank speech. The colleague from the World Bank said that what they found out is that actually many of the online workers that they found engaged in this type of worker comes from rural area in developing countries. Most likely, it is possible to think that actually these people didn't have before access to this type of job. And so this type of job could become a source of income. It could become an opportunity. However, at the same time, we also should balance this opportunity with the challenge associated to the fact that you can actually work on the other side of the world. And one of the first challenges is that when work has been fragmented and has been spread out on the global value chain, it basically means that it's completely unregulated and is completely invisible for most of the time. So what does this imply? What are the actually challenges that are associated with this? Now, the first thing that, of course, comes to mind is what type of labor protection do they have? What type of labor security they might have? It's how actually they are incorporated in any legal definition of work or any worker status. This could be the first question, because normally we are used to think about labor protection as associated to a specific worker status. We know that employees, they enjoy some type of labor protection, self-employed, they have different type of protection according to the different countries. What about these people? Who are they? Where they qualify? How do we actually put them in the picture? And this is the first thing. But there is also another aspect that today is not being brought up very much. And it is like the competition. It's been talked about a little bit like about, sort of like finding way of leveling the playing field. But there is this aspect, which is also important, which is when you actually are fragmented the work, over thousands of different countries. And when you're actually like entering new countries, you're definitely lowering the entry barriers. You're definitely giving a source of income, as an opportunity of income for people who perhaps, would not be in that position before. But at the same time, you are also creating a sort of like unbalanced situation in that specific sector, in that specific countries where traditional business are operating. And which are the differences? That traditional business, they keep working according to the national legislation, according to the national rules. What are actually these new, how these new business are actually interacting with this environment? So another question that it comes immediately after this consideration is that how do we ensure that this business model becomes not only equitable, but also sustainable over time, and actually promote, also like the development of the countries where actually they are reaching out, the countries they are trying to reach out. Now, this is, it's just, to give a little bit of an umbrella of some of the topics that have been pointed out during the discussion today. And I don't want to take much time talking about this, but I think it is important to keep this in mind, because when we're talking about regulation, the regulation of this new type of economy and the platform economy, those are important elements that should be kept in consideration, together with another element, digital infrastructure. The lack of digital infrastructure of the country is already like some sort of dividing element. It's already telling you which country is going to play the game and which country actually is going to be excluded by the game. And another potential issue that should be considered is that for those countries that do not have strong digital infrastructure as such, then we might want to ask, what is the role of platform in engaging them and providing at the same time the digital infrastructure that they need in order to provide the work? So those are the many issues at stakes. Now, what we have to, as International Labour Organization, what are we looking at? Well, the main purpose of the International Labour Organization, of course, is that to promote decent work for all workers, so including platform workers. And there were like issues related to this new form of work, and there was an expert meeting in 2022. The expert meeting came out with some resolution about what the position of the ILO should be, and then following what was the result of the expert group meeting, the ILO governing body in March 2023 decided to put in the agenda of the 113 conference the topic of decent working platform economy. So basically, it basically means that we already started the process, to start discussing potentially the promotion of some standard setting for decent work in the platform economy. Where are we at this stage? So let me give you a little bit of an introduction of how actually this works. So after the expert meeting group, expressed the position, and after the governing body decided to adopt it, then the first step is that the ILO has been asked, the office has been asked to produce what is called in the jargon, it's called the white report. The white report, you can find it online. It's called like decent work, recent development in decent work in platform economy. And it is basically, it's downloadable, it's free for everybody to look at it. And what it does, it collects basically all the information about the legislative initiative that have been undertaken already by member states on the topic of platform work. At the moment, we have collected 14 legislative initiatives around the world that comes from all the different parts of the globe. And what we have is that the majority of initiatives basically fall in 4 main groups, which is some initiative amend existing legislation, some initiative, like for example, this is the case of Italy, this is the case of Belgium, this is the case of Chile, this is the case of Colombia as well. And then there are, and if I got some country wrong, I apologize, but in the report they are correct. And the other alternative is that actually they set out specific legislation about platform and about like platform work in general. And then there is also like they look also at the sorry, I just lost the track coming back. Yeah, it's not here, so forget it. Okay, the third one is like creating like a specific legislation, as I was saying, and the other one is actually the implementation of collective agreement, because this is something that also has been kind of like it's developing, and we've been seeing in more countries that are starting actually finding having like collective agreement between platform and workers. The majority of the collective agreement, of course, relate mostly to web location-based platform, so all location workers, basically platform workers. The reason is obvious. They are the most visible one. So those are the one also which are the most immediate to organize, the most easier to speak to, and also are the one that actually trade unions have more facility to reach out. So this is like the status of the actual status of the legislation in different countries. Another topic that I've also observed, and there are some specialized law that actually extend some of the labor and the social protection already existing for worker in short-term contract or worker in so-called non-standard form arrangement that have been extended also to platform work. Just to give you an example, I make the example of my country, for example, in Italy. In Italy, there has been promoted a legislation that basically extends the healthcare coverage to all the riders. Now, this brings me to another point. How these are enforced? Are those really enforceable? I mean, are we checking on the way actually they've been implemented? And this is another important point, because what it is that actually is missing is data coverage, is actually the possibility for countries, for government to actually track the activities, but not only for that and governments, but also for trade unions. So this is another element which is important, because of course, platform, they do have the data, they know, they kind of like can track all the workers on the data, they know how many workers they have, they know which are the schedule that they follow, but this information is an information that basically stays with the platform. So this is another issue that, it will be kind of like, has to be taken into account in the moment in which we are thinking on how to rebalance the power between platform and workers. Now, how the procedure of the standard setting is going on. There is not at the moment an official position of the ILO, because we are still in the process of listening actually to what constituents have to say. So the process is that at the moment, there has been a questionnaire, has been formulated a questionnaire. The questionnaire includes like 81 question. The 81 question try to cover all the aspects that have been somehow pointed out today, that goes from which are potential definitions in terms of how to define which is the employment relationship, how to deal with the use of algorithm works, how to guarantee freedom of association and collective bargaining, how to make sure that the minimum OSH standards are ensured. So the topics are all there. And the process, the next step in this process, it will be that we're going to wait for the reply that it comes from all the countries, from all governments and trade unions and employer association from the different member states. And then we're going to basically summarize this position, the reply to each of the question in a report that is going to be published in February 2025, which is called the Yellow Report. The Yellow Report, it will be the first step in order, to understand more or less where we're going with this potential instruments that will come out from the discussion. And it will be also the basis, the legislative, the first was not really legislative basis, but it will be the first, let's say, condensate information that will be used in the ILC when government, worker, and employer will meet in person June next year and start discussing, the potential instruments. Now, in terms of which are the main developments in the particular in the different countries, I can give you some examples if you think that this could be interesting. For example, like if we look at the classification issue has been clarified in some countries in using some criteria that basically try to measure if the platform work exert any type of control or direction on the worker. In the questionnaire, we do not ask nothing about the employment relationship, but what we state is that we are in line with what the Convention 198, ILO Convention 198 state, that basically the employment relationship should be assessed by the premise of fact, which basically means this is what the question that we ask, to government and to constituents. We ask if they agree that this is going to be the principle, which basically means that independently from what type of contract did you actually sign up with the platform, what is going to define what is the employment relationship with the platform, it will be actually the fact that actually assess the characteristics that actually assess the type of work that you perform. So this is like an example of the type of question that have been included in the questionnaire. As for the some extended social security and labor protection cases, what I can make, for example, I made the cases of Italy already, but for example, there is also the case of the Republic of Korea, in which basically the Occupational Safety and Health Act extends the protection to cover passenger transportation. So they do have to provide that platforms are responsible for measures to prevent industrial accidents, basically. So it is like a proactive action that they took, the Korean government took. In Portugal, again, there is the scope of the legislation, again, for the OSH is still relating to passenger transportation, is that the operator, that is the person who actually provides the transport services, not the platform, is responsible for observing all the legal provision related to occupational safety and health. So as you see, there are already two completely different way of approaching the same question. So what is going to be very challenging is the moment in which we're going to receive the reply from all the different countries and from all the different constituents to find the right balance in the general practice that have been already adopted. As for example, the other two topics which are very, very, let's say, hot in terms of how to regulate it is, of course, remuneration and working time. The two things have been addressed today, and the role of the algorithms in defining remuneration and working time is also taken into account. So to give you some example, remuneration-wise, both in California, there is the ABC law, the California law basically states that the remuneration should be assessed either, if you are an independent platform worker, you should be related to the provision that are in the labor code relating to the piece rate compensation. And if you instead are an employee, then they should follow the minimum wage for the same sector. And in any case, even when you are in a piece rate situation, if the final amount doesn't sum up to at least the minimum wage, then your salary should be increased. So this is what the legislation say. In Chile, for example, we do have another type in which basically the remuneration of platform worker is considered as to be 120% of what it is like the average payment for the people in the same occupation in the same sector. And the 20% more is actually added because they wanted to take account of the waiting time. The waiting time, and on this one, I would like to make a remark on this, because this morning, when we were listening to, the panel in which they were talking about how to define waiting time, the waiting time is not just the waiting time that occur, when you go to pick up the delivery and you have to wait because your delivery is not working. The waiting time includes also the time that you spend between one task and the other task, the assignation of task. So this is an issue that at the moment, the positions are very clear from workers and employers. For employers, this is not working time. For workers, this is working time. So this is just to give you an example of one of the challenges, what it's going to be, like how to address, this spell of time where they are worker in this spell of time considered at disposal of the platform or not. How do you judge? So if you think about perhaps some situation, you can imagine by yourself directly some situation in which you can see that clearly as, as effectively being at disposal of the platform. But at the same time, there might be some other business model where this clarity is not so obvious. So it's not such, it's a tricky issue. Indeed, what we're doing in order to inform us better and to get ready for this discussion that eventually will come, about this specific topic, we are also preparing some additional studies in which we're looking at some practice in specific countries, particularly in countries that have developed collective agreement in which they deal with the issue of remuneration and working time, to see how countries are actually trying to solve this issue and which are the strategies they are implementing. So that will be this is one of the strategies that they are following. Another moment, as we said, working time, for example, at the moment, what we've seen is that the majority of the legislative intervention that we found are legislative intervention that are mostly related, again, to on-location workers, particularly to drivers and riders. And basically what they are stating are things like, for example, if you've been working for 9 hours or 10 hours in a row, then the platform should stop, assigning you a task. In some countries, the regulation goes even farther, and they say that it's not the responsibility just of the platform, but if there are aggregator, the aggregator should be responsible for that, which basically means that if there is an intermediary that is actually coordinating the work of drivers over more than one platform, they have to make sure that platform worker works in multi-homing, it's so-called multi-homing. So for more than one platform, they are actually respecting, this limit of working 10 hours and that they should not receive further tasks. Now, those are just examples on how they're trying to deal it. Another issue, which is very, very relevant, is about, for example, fundamental principle, which is about freedom of association, collective bargaining, and all these items. If there is one position that is very clear for the ILO, is this one. I mean, fundamental rights, those that are considered fundamental rights for ILO should apply to all workers. And this is something where, let's say, the threshold is kind of signed, in the sense that the freedom of association, collective bargaining, the possibility of OSH, all the elements that fill, the fundamental rights chart for the ILO, this should apply to all workers. And in particular, we are also trying to see how to make it possible, to favor the emergence of form of negotiation. Because one of the other aspects that is very important to consider is that we are not in a traditional setting. We are not having employers of workers, which basically means we are not having business association and trade unions. But most of the time, we are having platforms that do not recognize themselves as employers, And we do have worker organizations that actually are not recognized as official trade unions. And so it is also important to look how to deal with this new form of stakeholders that are actually relevant in the discussion, and they are playing like a voice in defining what should be the common rules that they agree. Another element is the use of algorithms work. So when it comes to the use of algorithm works, the ILO does not have any standard, does not have any particular standard in place. The only reference is the code of the privacy code, which is 1997. And it is basically data protection. It talks about workers' data protection. And that's the only reference there is at the moment in the ILO. But this is a very important topic because, I mean, it was already pointed out this morning by Phoebe Moore. I don't want to, delve too much into this because she already pointed out how important it is to understand what they do with the data, how if they monetize the data, for how long they keep the data, where they store this data, and actually, I mean, who has the right to access this data. And one of the things that perhaps it should be taken into account is that there are in place some instruments, the GDPR, for example, for European Union countries, or other privacy codes that, like, for example, in Brazil, there is another one, in the United States, there is another one. I mean, they might actually give some guidelines on how data should be treated, how data should be shared, how data should be used. Why this is important? This is important because if we're trying to rebalance the power into into the dynamic of this new negotiation, one of the elements is that all the players who are sitting at the table, they must play with the same cards. The idea is that they all have to have the same information. If you are withholding information, it will be very difficult to find an agreement on specific topics. I mean, this is trivial. It's not, I'm not saying nothing particularly new. Even like at the beginning of the trade unions, it started like this, when there was when the factory came out, I mean, like trade unions were born because there were people who actually went there and see how the assembly line was working and said, okay, no, we want to discuss this. So, but if you cannot see that, you see, you are kind of like participating, but not seeing all the information, not getting all the information. So I think that one of the approach that should be somehow encouraged is to find a way to respect, of course, the trade secrecy and the privacy, and there's no need to share the algorithm source. There's no need to share information about, the business model of the platform. There is absolutely no need to do all of this. But there is a need to find like an agreement on which type of information should be common and which type of information should be shared not only with the workers, but also with government. Because in the moment in which, for example, there is a need to look at the implementation of some specific regulations that are put in place, even like the government institution, the authority, labor authority, they might have some difficulties in finding their way through understanding if you are actually complying with the legislation or not. So this is definitely another aspect. Now, how to balance all of these different divergent opinion on the different topic? Well, this is not really the role of this is part of the role of the ILO, but this is actually mostly what is going to happen during the ILC. During the International Labour Conference. During the International Labour Conference, this is what is going to be the discussion about. So our role at the moment is to provide, the view that it comes from all the different constituents, to try to grab as more information as possible on existing practices, and to point out which are the opportunities that might come from this new model of work, and the difficulties and the challenges that might be associated with this, and then, try to give all the elements to all constituents actually to participate democratically to the discussion. Because this is one of the points that I think it is important. The way in which the ILO constructs the standard setting, it's open, it's transparent, and it is very participatory. So it is kind of like listening to the voice of all the stakeholders who are involved. As for the, I don't know how much time do I have, but if I have to, I'm sorry? No, I still. I can go for another half an hour? Well,
Say this 5 to 5, I think you have 10 more minutes. 10 more minutes.
10 more minutes, okay. So another element that I think it is important also to point it out is that since we do have 10 minutes, do I have 10 minutes? No, there is this agreement here. Yes, okay, that's fine. So, I mean, another element I think it is very important, when we're talking about platform work, as a platform work different from other type of organization of work, as a very, very singular cross-border dimension. And the cross-border dimension it becomes super important when it comes to dispute resolution, and it becomes very important also when you are actually trying to implement some of the legislation in each of the country. Just to give you an idea, I'm going to make a practical example of some countries that actually try to introduce some tracking, like sort of legislation, because they wanted to understand how many platform workers they have in their own countries. But then the reality is that when you implement a legislation in one country, it applies only in that country. And if the platform doesn't have an headquarter in that countries, they are basically exempted. So which basically means that particularly for online workers, you are very not in the position of, knowing how many online workers you have in your country, at least using administrative data. So how do we deal with this? Well, for example, like in the Directive of the European Union that Manuela was talking about this morning, was presented this morning. This is one of the, let's say, this is one of the good positive like features of being a union of countries. You can make a decision where all countries have to basically speak to each other and pass information to each other. But the reality is that we need to upload that to a different level, to the global level. We do need to have this in a more like global perspective, because if we want to track for real the phenomenon, if you want to make sure that there is for real decent work for all workers in each part of the globe, we need to have some mechanism that ensure that actually all countries might be somehow held accountable, for the way in which they are carrying out platform work in the specific country. This is also to go back to what was saying yesterday in his keynote, Mark Graham, when he was talking about it's very difficult, to ask to a country to improve the working condition of the country, because they know that the threat is going to be, okay, we'll go to another place. We just move everything to another place. And this is not a novelty. It's not like, we haven't seen this before with traditional industry. We've seen this also with traditional industry. Now, which is the difference? That the cost of moving is much lower. I won't say inexistent, but it's much lower. It's definitely much lower. So we do have to have this sort of like global understanding and global approach in mind, because otherwise it will be kind of like difficult, to make it possible to have actually decent work for all the people in different countries. Now, before I conclude, I actually, okay, I'm gonna just give you like an idea. I wanted to give you an idea how the questionnaire is prepared, but there's no way for me to show. But I want just to give you an idea of which are the topics which are covered in the questionnaire. So just to make you understand how actually we are trying to engage the discussion with all the constituents, and in the topic that are included, the things that we have, of course, I mean, as I said, there are the fundamental principle, and rights at work, which are the fundamental principle of the ILO. We do have the OSH issue. We do have violence and harassment. We do have the employment promotion, which is also very important. And we do have the employment relationship, the use of intermediaries, because this is another element which is quite important. Because, for example, like there are some legislation in some specific country where they introduce some legislation, but then they were circumvented by using, intermediaries. So this is one of the questions that we are actually asking to countries. How do you think that we should deal with the use of potential intermediaries? The remuneration of working time, I mentioned it. The impact of the algorithm, I mentioned it. The protection of personal data of platform workers, also this one was mentioned. Social security. Now, social security, this is an important point, because social security, it is one of the fundamental like core principle of pursued by the ILO. Social security is, the ILO is pursuing like universal social security for all workers. What is the situation at the moment and how we can actually implement, improve the situation. So the situation at the moment is that actually for the very little information that we are able to collect on the coverage of social security of platform workers is basically that the majority of platform workers are actually covered by social security. They are covered by social security because they actually have a double source of income, which basically means they're not just working as platform worker, but they work as regular worker, plus they work as, traditional worker in the traditional sector. Just like, for example, taxi driver or normal taxi driver, but on the top, they also work for platform. Those people are covered by Social Security, but they're covered by Social Security that it comes from the traditional employment. And this is another aspect that should be taken into account. Because, there is a sort of like a need to understand who has to be held accountable in case of accident, who has to be held accountable in case of distress, and how to share the responsibility between traditional employers and platform, if there is a responsibility to share. So those are other elements. And another aspect that is also important, the Social Security is very much related to the cross-border situation as well. If you're basically hired by, well, hired is not the right term. If you are engaged or if you are provided a task by a platform that actually is staying in a different part of the world, you most likely are not paying any Social Security contribution. Even if you are like a self-employed, you are not even applying on the voluntary scheme, you are basically inexistent in the thread line. Now, if this is the model, and this model is expanding, because this is what we are also this morning when Manuel was presenting the data, and even from the World Bank, when they were saying like, that it's already 12% of the total market online services, the trade of online task is already account already for 12% of the total work. So it's basically give you like the magnitude of how big is going to be this in the future. So if we look at this, another important point is how do we make the social security, the national security system sustainable over time? So do we have to go as, for example, like World Bank this morning was talking about partnership, with fintech, health insurance, and etc. What is the model that we want to pursue? This is an important question that we should ask, and that governments should ask, and constituents should ask themselves when they reply to the questionnaire, because those are the things at stake. This is what we're talking about. It's not just regulating the small business here, but it's also regulating how actually we perceive the access to some fundamental rights that have been actually considered acquired for many years, but now have been becoming like less, let's say, tangible, if I can put that this way. Another aspect is and on this one, perhaps I will close because I think that my time is up, but another aspect and the final aspect, which is not less important, is suspension, deactivation of account, and termination of contract. So far, there are no specific legislation regulating, which are the rules according to which platform may decide to suspend an account, to deactivate an account. It's normally decided by the terms and conditions of the platform. So each platform has its own procedure. It could be completely different. So one might ask, it is true that many of the platform workers are, the majority of them actually are like double income, they're double earner income, because they have like a work in the platform economy, they have a work in the traditional economy. There is, however, a part of platform worker, they actually rely on platform work as their primary source of income. Now, what happens if an account has been suspended on grounds which are not identifiable, and this person has to go through the scrutiny process of the platform, which might take 2 days, 3 days, at the best, a week. And what happened in this week if this is the only source of income of this person? This is one of the topic. This is one of the issues that needs to be addressed. This is one of the questions that basically we ask constituents to reflect on and to give us their opinion on how to actually deal with this possibility. Because in this case, there is a clear potential disadvantage for the person who is actually engaged. At the same time, of course, if like this person is clearly behaving in a sort of, there is a big case of misconduct, or there is even like a danger for whoever is the users, let's say, of the service, then of course, I mean, platform, they do have the right, not to be held accountable for the misconduct of one of their workers. So the real issue is, how do we find the right balance, a common agreement? How do we basically manage to put these two issues on the same, the same plate of the scale, and see what it is like the fair solution that would allow some protection to the worker, but at the same time would allow also the platform, to guarantee that there is not a misconduct and misuse, that they cannot somehow intervene immediately to stop. So this is just a very, very like quick presentation of the many issues that we're going to be facing in the next 2 years. And as I said, the procedure is, at the moment, we are in a sort of like consultation hearing phase. We are very looking forward to receive, all the questionnaires that comes from the different constituents, and we are still at the beginning of the process, so there are no trends that I can actually share with you or how this is going to go. But I mean, like, we are very, very keen to see how this is performing, and we do need actually the help in general of any stakeholders interested in the topic on giving us, any potential information and any potential help, in how to solve the many tricky issues that are ahead of us. Thank you.
No, thank you very much. We have now like 10 minutes for questions and answers. So, Jan is first.
Hi, I was wondering, and to which extent does the EU directive on ESGs provide an opportunity to reinforce decent work throughout the talent supply chain? I work for an HR employer. If you see what the demands are from investors and from shareholders towards enterprises in terms of CSRD reporting, they push that through to their suppliers in their supply chain in terms of environment, in terms of transparency and governance. Yeah. The S in ESG is very demanding on reporting on all workforce, all personnel that you engage with. Also in terms of compliance with social security and labor law. So I was just wondering, is that something that the ILO is taking into account? Is it an opportunity, or am I just dreaming?
No, that's a very good question. And this is one, okay, there is not, if you're asking me if at the moment there is a specific, this is an item in the questionnaire that you are looking at, the answer is no. And the reason why this is no is that because this is not really specifically to the mandate of regulating just platform work, because this is more like associated with like the value chain and the use of technology along the value chain. And I'm not saying it's not important. I totally agree with you. This is an important element. But at the moment, the ILO is not taking this into account. However, this does not exclude that if from constituency, it comes up a request or a comment that this should be an issue that is also should be addressed in the instrument, that it might become, also an element. Because this is, as I said, we are in the hearing phase, in the consultation phase, which basically means that if there are even things missing, those things missing could be pointed out. Then, of course, I mean, it depends on the strength of the request. And by the strength of the request, I'm not saying by whom the request comes, but by how many, let's say, and I'm not don't want to make it sound like it is a statistical exercises, because it's not. And because if something actually is missing and it makes sense to be there and the office deem an important element to be considered, this is actually gives an opportunity for the office to propose to the governing body actually to look at this issue as well. So at the moment, if you're asking me, at the moment, there is no issue like that treated in the questionnaire, which does not exclude, however, that this is an important issue that could be included if raised by the constituent.
Any more questions?
Thank you very much. I was just wondering, actually today someone else mentioned already, maybe Piobe. Do you, you will have this meeting next in the ILO conference with employers and trade unions. My question
And
is,
governments.
and governments, yes, tripartite. My question is, whether you made any special effort to bring in the real actors of this topic, which
Absolutely.
is the platforms and platform workers. Because I'm not sure the traditional employer and trade union organizations
Absolutely.
represent them.
Mhm.
That's the number one. And then the second one, I forget. So I will ask you during the
Don't worry.
drinks. I had two, but
Don't worry, you're very welcome to retake the floor if it comes back. So as for you're absolutely right, because this is what I was saying before. I mean, like in this specific case, of platform work, the traditional actors are not the traditional actors, because you do have work organization and business, well, and platforms that, you know, are kind of like different from the employers and the trade unions. But so the ILO, basically what the ILO asks to government in particular is to consult with whoever they deem necessary in order to formulate, you know, the reply to the questionnaire. So which basically means that if a worker organization, which is not recognized as such, is not recognized as trade unions, could even send their reply to the questionnaire. However, those replies to the questionnaire will be treated as received by others. So they will be received, they will be treated as like additional, you know, but they won't be, they're not binding, because the only one that are bindings are the one that comes from the constituents. So they comes from the trade unions, they comes from the government, or they come from the Association of Employers. Now, what is happening is that actually both Association of Employers and trade unions are very well aware that there are platforms who are not part of the Association of Employers, or there are worker organizations who are not part of the trade unions. So they are making their own consultation, because they are very free to do that, and we actually encourage them to do it. So it is absolutely what is going on. We know for sure that the IOE is actually listening to, you know, they're basically having a direct channel of communication with platform, as much as we know also the ITUC is actually consulting with worker organization that might not be recognized as official trade union. And also government, actually they asked us if they can consult with different organizations, which are not the former one, and we do not have any say on that one. I mean, like the only recommendation that comes from the ILO is that, you know, those are the binding, those are just from the reply that are binding, that are the one that comes from the constituent, and the consultation you do are absolutely free. You know, it's up to the government, it's up to so actually this is an invitation, you know, to work organization or to platform who have not direct access to neither Association of Employees or to trade unions, actually to get in contact with them or to the government directly in order to showcase, you know, their suggestion.
I remember the second question.
Please.
We know, I mean, we saw this very different practices in different parts of platform work.
Yeah.
So your examples were always mostly on location workers.
Yeah.
I think there is a need for differentiating different categories, also for maybe or convention or whatever you are going to do, because I think they are very different. To put the same rules with so many different profiles of workers, it's also risky to alienate all of them.
Mm-hmm.
I mean, it could be considered as one.
It is indeed one of the questions in the questionnaire. We do ask if the instrument should apply to all digital platforms, to all digital labor platforms, sorry, or to all platform workers. we do it. It is one of the questions. It has been taken into account. I mean, like the position of the ILO on this, it's very clear. The position of the ILO is that there are some, as I said, the fundamental convention, the fundamental rights convention that has to be granted to all workers, the fundamental one. However, within the specific regulation of specific items, the ILO recognized the liberty of the countries to, you know, to kind of like fine tune, to adjust it, and also to express, if in the case of the question and in particular, to express the willingness of separate like different regulation for different type of platform workers, asking if, for example, there's one question is exactly this, ask if the instruments should be applied to all platform worker or just some types of platform worker.
Question, but in the meantime, I invented another one. What we see in the United States,
Yeah.
and what we see in Europe is that platforms organize to advance their way of thinking how this question has to be resolved, right? So they have their association and they were lobbying for the solution for which they thought it's the best for them. They had a great, huge campaign, expensive one in United States to overturn one important piece of legislation, which was like very good for workers. So are you, do you see an activity like that, which is focused on on ILO, because you are maybe the last frontier discussing this issue?
Look, the ILO, as the good thing of the ILO is that the ILO is not the first time that he found himself in being in this situation. It's a tripartite meeting organization, so it's not like platform are not the first employers lobbying. I mean, like history of lobbying, I think in the history of industrialization are plenty. There are plenty of examples. So I do think that actually the ILO has its own mechanism to know how to stay balanced and how to basically deal with the pressure that it might come from both sides or even from government. So the ILO is there to be a tripartite meeting, to be like the democratic place and participative place where to hear the different voices is. So there's a lot of years of experience on that part.
One more question? No. This one.
I mean, I'm really interested in this point around the kind of mechanical Turks and the online kind of platform work and things like this. And I'm wondering if there's a case to be made that there's labor market. There's like, obviously it's labor law arbitrage, because that could easily occur where the liability questions matter. And I'm wondering if, because I remember the kind of home working convention. This is a genuine question. I can also ask you later, but because the question for, given people are working in their homes often on the screen, sort of like the screen online platform work. So yeah, so is that a possibility for one of the interventions that could lead to better protections or not? That's actually the question.
So there are actually, if you take like the normative gap analysis, it does exactly this. So the study that we did is to take like the convention that are already in place and to look, you know, to which extension, you know, you can actually adopt them. You can actually like consider usable, you know, for platform workers in different conditions. In this case, like, you know, like domestic work, like home work. So there are some limitation that it comes from the fact that some of the convention, now I don't want to tell you, I mean, I really need to go back to the normative gap analysis to reply to the specific point, because I don't remember exactly what the convention says. However, the convention, if I remember correctly, but, you know, I put like an if on the top, it is basically, it covers wage employees. So if that's the case, of course, that there is a limitation, because, you know, it basically means that it would not apply to those who are not wage employees. And so this is something that's exactly the scope of having normative gap analysis, is to put in the discussion, you know, this kind of limitation or drawback that might exist.
Oh, no, it doesn't matter. Oh, oh, hola. Let's do karaoke later. No, no, just the final thing then. No, I was just curious about it, not least because with COVID, this kind of remote work, mobile work, telework, however we call it, whatever we call it, because working anywhere all the time sort of
Yeah.
thing, that whole, the dream of just the mobile worker, of course, has been a little bit shattered. So I'm just curious if there's like some scope to, again, put a little bit of a spotlight on that convention, just partly because people in the unprotected space for where that kind of work happens, the not sort of in-person work, and there are different categories for how that looks. But anyway, that's really interesting. So thank you. I just wondered if any more had happened in that space. So thank you.
Well, actually, I mean, like remote working, it's already regulated partially because teleworking and remote working are regulated. The issue with remote working and teleworking is a little bit the same as the home work. It's for waged employees, it's wage employment. So being a wage employment, it has some specific like, kind of like limit, on how to apply and how to whom it applies. So I think that actually those legislation, those conventions already existing, they're gonna somehow, in the moment in which there is a decision, that those are issue, it might become one of the requests, for example, it might be to extend that. Yeah. I mean, I'm saying like this could be, it's pure speculation, but this could be some of the things that might happen. And we really don't know at this stage, but for the time being, those were thought in a different time. Exactly. And well, we can, I mean, like, I see your point, but of course we cannot do it ourselves. It's sort of like, as I said, we are just the kind of psychological depository of the rules, but we're not the rule makers, because this is, yeah, there are overlaps. There are overlaps.
And this, I would like to invite Branka to give her concluding remarks and thoughts at the end of the day.
No, I'm linked to the chair. I cannot move. I was standing up. I just stay here. No, I'm joking. I think I freed myself.
So thank you all for being today with us. I'm trying to find a spot where this light is not really attacking me. I apologize, first of all, for this very fast-paced conference. But this is the way we work, because we don't have much time to spend more time with you. This is this is a result of our 4 years long work in terms of research, in terms of collaborations, and in terms of where we are at this point of time. 4 years ago, when we started, regulation was not at all on the horizon. As I've said, platform workers seem to be like more exotic topic, at least in this part of the world. Today, we have some resolution, I would say. We have a legislation on horizon, but working conditions remain relatively poor. In 2 years' time, I hope we are going to meet again to see what really has happened in this period of time, I mean, from now to then. And I hope that this is not going to be worse than it is today. So this is really my hope. So I'm leaving you with this thought. I know that this is not overly optimistic, but maybe it is not too pessimistic. So before I really close, I would like to thank all my colleagues who worked with me. Now you can really put faces on their faces, and I'm like now really tired. So the words are like going somewhere else. So first of all, I want to thank Tanya, my colleague. Valentina, whom you met. Mira. And I'm missing Sonia Lundin. So she's waving from behind. But there are also 3 more people that you don't see now because they're either behind. So they've been helping out with Zoom moderation, Luba and Marco. And there is a 3rd colleague who was with us and he just rushed away to prepare the exhibition that is actually going to be officially opened tonight at 7. And again, and this is really my last word, thank you all the partners, they're all European partners that made this conference possible. So thanks again for being with us and see you in 2 years' time. And now cocktail. Oh, drinks.